You make sandwiches at a sandwich shop. Can your employer force you to sign an agreement that says you won't go work for a competitor for a year if you quit your job or get fired? I'm Karen Michael. You're listening to The Job Judge. Welcome to The Job Judge, where we navigate through all those legal landmines and workplace dysfunction that I'm pretty sure is happening in your organization. I'm Karen Michael, your host of The Job Judge. I've been an employment lawyer for 31 years, a former HR executive. I wrote the book, Stay Hired, How to Thrive and Survive in the 21st Century Workplace, and I'm in your workplaces every single day. And here at The Job Judge, we are going to make workplaces work because you and all your family deserve a safe, civil, and legally compliant workplace. Now, you're not going to want to miss an episode of The Job Judge, so be sure to like, subscribe, follow, comment, so that you don't miss an episode of this Job Judge. And you probably want to share this with your manager, your employer, people that are running a business because they need this information. Now, a couple ground rules. First, I can't give legal advice on this podcast. It is just general advice. And sometimes we talk about sensitive topics, not necessarily today. Today, we're going to talk about a legal topic because there's a hot take. Just earlier in April 23rd of 2024, the day we're actually filming this podcast, the FTC has come out with a new rule. And now we know that if you're making sandwiches for Jimmy John's or anywhere else, you can't be forced to sign an agreement that you won't go work somewhere else in competition with that employer. But it's not just sandwich shop Jimmy John's, it is all employers. The FTC just came out with an all-employer ban on non-competes. That includes if you're an executive, if you're a top salesperson. Any employee cannot be compelled to sign a non-compete. So what is a non-compete? So what employers do is they require as a condition of employment. So the theory is that there's adequate, quote, consideration under contract law. As a condition of employment, so I'll employ you if you agree that if you quit or you're fired, if we fire you, you still can't go work for a competitor. And they define it in different ways. So sometimes it's defined by geography. You can't go work for another employer within this scope of territory, or it's defined by term, like it's 1 year, 18 months, 2 years. 2 years has always been considered on the way outer limit of what is reasonable. And every state regulates non-competes in different ways. But the federal government caught wind of some non-competes that it felt were slightly abusive and decided to really get serious about non-competes. And it kind of started with Jimmy John's. And this article from way back in 2014 talks about how for many who work at Jimmy John's sandwich shops around the country, a piece of paper they signed when they started stands between them and getting another similar job. The non-compete contract says if you leave, you agree to not work for a competitor for 2 years. So here you are making an hourly wage at Jimmy John's. It's not like you have trade secrets. It's not like you have the secret formula for how to make the sandwich. I mean, you're just a sandwich maker and you're prevented from getting another job. Well, what if you hate your job? What if your boss is a jerk? What if your boss is a sexual harasser? What if it's an abusive, toxic work environment? You got to stay, because if you don't get to go work anywhere. I've never been a fan of non-competes. And because people should be able to go where they want. You know what is the antidote to a non-compete? It's creating a work culture where people want to stay. You shouldn't need a non-compete, worry about a non-compete, if you're creating a work culture where people want to stay. And so one of the things that happened as a result of this particular, not just Jimmy John's, but some other settlements that the FTC, the Federal Trade Commission, had, is that they put out a proposed rule. And on April 23rd, they finalized the rule, and it goes into effect in 120 days. But before that, last year, the FTC announced a crackdown on a few employers that they felt were exploiting their employees through their non-competes. And so there were 3 settlements, and I think it's important just to kind of see the history, the backdrop of why we got to where we are. And this article from the FTC, it's from their website, talks about how they're taking legal action against 3 companies and 2 individuals forcing them to drop non-compete restrictions that they imposed on thousands of workers. Drawing from their substantial expertise, the actions mark the first time the agency has sued to halt unlawful non-compete restrictions. So in 2023, they sued to halt certain non-compete restrictions. Now in 2024, they've put out a final rule banning non-competes entirely across the United States. And the cases were like this. There was one case against Prudential Security, and in its complaint, the FTC said that the two affiliated Michigan-based companies and their co-owners exploited their superior bargain power against low-wage security guards, requiring them to sign contracts containing restrictions that prohibited them from working for a competing business within a 100-mile radius of their job site with Prudential for 2 years. And the security guards, these are security guards that aren't subjected to the trade secrets or special secret sauce, or they haven't invented something for the company. They typically earned hourly wages at or near minimum wage, yet the company's standard non-compete clause included another restriction that required these security guards to pay $100,000 as a penalty for any alleged violations of the clause. And so employers, if you're upset over this new rule on non-competes, you need to understand that you're the reason this rule was created, because you went too far. Instead of just putting these non-competes on your top salesperson or your top inventor of something, you put it on everybody. And so now you can't have nice things, because now you can't put a non-compete on anybody. There was this other settlement that they talked about in this FTC settlement from last year. And according to the case, for more than a decade, an Ohio-based company imposed non-compete restrictions across employees for a variety of positions. They typically banned workers for 1 year after leaving this glass company. They prohibited them from working for, owning, or being involved in any other way with any business in the entire United States selling similar products or service without the prior written consent of O Glass. They had more than 1,000 employees were subjected to the non-competes, including salaried employees whose work with the glass plants, they formed equipment and other glass production. And then finally, the other non-compete that they refused to uphold was one where the workers were prohibited from performing any business in the United States, Canada, or Mexico that was involved with or supported the sale, design, development, manufacture, production of these glass containers. All of these non-competes were just ridiculous on their face, and the FTC had to enforce it. So what does the new rule say? Well, I'm looking at the FTC fact sheet on the proposed rule issued on April 23rd. And according to the fact sheet, the final rule bans new non-competes with all workers, including senior executives, after the effective date, which is 120 days after the issuance of the rule. It says specifically the final rule provides that it is an unfair method of competition and therefore violates Section 5 of the FTC Act for employers to enter into non-competes with workers after the effective date of the final rule. Now, what if you have an existing non-compete? According to the new rule, the final rule adopts a different approach for senior executives than for other workers. For senior executives, existing non-competes can remain in force. So if you have an existing non-compete, it remains in force. But if you happen to leave your company and go to another company and maybe violate or not violate your non-compete, you can't get a non-compete at that other company. Existing non-competes with workers other than senior executives are not enforceable after the effective date of the final rule, which is 120 days. The rule says that fewer than 1% of workers are estimated to be senior executives. So what's a senior executive? What's the dollar amount of a senior executive? The final rule defines senior executives to refer to workers earning more than $151,164 annually who are in a, quote, policy-making position. So it's a two-part test. So if you're making less than $151,164 and you have a current non-compete, in 120 days, that non-compete is going to be unenforceable. And if you have a current non-compete where you're making that amount or more, the question will be whether you are in a policy-making position, and that will have to be decided based on the rule. Now, they claim this is going to help reduce health care costs costs and cause new businesses to be formed and a rise in innovation and a higher worker earnings. Forget all of that. I think it's going to create better work cultures. It's going to allow employees to leave work environments that are toxic, harassing, bad managers. It's going to force managers to have a better work culture, because if you have a non-compete on an employee, then you kind of have to force that employee to work there, whether they like it or not, whether you've done anything to promote a positive work culture. Now, keep in mind that even if you don't have a non-compete, that doesn't mean you can take things from your employer. You shouldn't be taking customer lists. You shouldn't be taking documentation. You shouldn't be stealing anything. Don't be sticking a USB drive in your computer. Don't be forwarding things to your personal email. Don't have another drive over here that you're sending things via the internet or via the cloud to save things from your employer. See, that's still theft. You can't take information from your employer. There's also no indication that you can't do have a rule where you can't solicit other employees potentially to work for you. And you probably might still have non-disclosure requirements, confidentiality requirements, trade secret requirements. So there might be still some requirements that you might have to sign as a condition of employment. But what you're not going to be required to sign is a rule that prevents you from going to work for another organization if you quit or are fired. I always thought it was a bit abusive to terminate an employee knowing that employee is on a non-compete. There are employers that do job eliminations, a reduction in force on an employee, basically saying, we don't need you here anymore because we don't have enough work, but you've got a non-compete, you can't go work anywhere else. And so because of these contracts that would exploit our employees, now the FTC has banned them entirely. Every week at the Job Judge, we answer an Ask the Job Judge question where I'll be the judge of that. This comes from Reddit, and the question is this. So I started a new job back in November last year. Most of my job can be done remotely, but it is preferred if I'm in the office. I have a toddler, so there are times when I needed to work from home because I couldn't find childcare for my son. It's never been an issue. And then yesterday she woke up, the daycare teacher had COVID, the daycare was closed. She sent a notice right away that she would be home, and apparently she got criticism and was told that when she's working from home because her toddler's at home, that she needs to use PTO unless working from home is pre-approved. And she asked, I answered emails, I did work. So my question is, can he force me to use PTO for yesterday, even though I did actually work? Now, if there wasn't a rule, I'll be the judge of that, by the way. If there wasn't a rule in place that you have to use PTO when you're working from home, then no, she shouldn't be required to use PTO. She should be paid her normal rate. But it is reasonable for an employer to question whether a person is really going to be fully functioning at home when that person also has a young child that they're caring for. So a good employer would say occasionally working from home when your child is sick is probably going to be okay. We just want you to be as productive as possible. But on the long-term basis, I don't agree that employees should be, quote, working from home while they're also tending to child care responsibilities or aging parent responsibilities, because you can't be focused on all things when you're trying to be focused on your job. And those kind of distractions are probably not a long-term solution. I know when we came back from COVID, there was a push to say, well, people are trying to find childcare and that's been a problem. And I wondered, were they not having childcare before? They were probably working their job maybe half the day and watching their child maybe the other half a day. And that's probably not a long-term solution. So making sure that you're working out with your employer that this is going to be temporary. Occasionally things come up. A good employer will be understanding that occasionally things come up. And we'd much rather you do some work from home than no work at all. So it's a benefit to the employer that you would be paid, especially as an exempt employee, for that time worked. So I would ask your employer to be as flexible as they can be, not force you to use PTO for the day that was, by the way, approved by your first manager. So there was no reason for you to have to use, in retrospect, PTO for that day. But employers, we can be a little more flexible with our employees, and employees don't expect to have full-time remote while you're also watching a toddler while you're at home. Now, every week we drop an episode of The Job Judge. You're not going to want to miss an episode. Be sure to like, subscribe, follow, comment, because somebody needs to hear this information. I'm Karen Michael, and you've been listening to The Job Judge.
So, quick update. Just after we filmed the podcast on April 23rd, when the new regulations came out, sure enough, a lawsuit was filed in the Northern District of Texas called Ryan versus the Federal Trade Commission. And their argument is that the new regulations are unconstitutional. And this is what they say in their new lawsuit. If ever a federal agency attempted to pull an elephant out of a mouse hole, this is it. So I guess it's game on. We'll see if these regulations actually stand. But for now, employers, I would encourage you to just look at your non-competes, see if they're a good idea. Maybe there's another way to accomplish what you're trying to accomplish without doing something like a non-compete, maybe through a non-solicitation agreement or something like that, because the state of this new regulation is up in the air, because I'm sure more lawsuits will be filed. So just wanted to make sure everyone had an update on the new regulations.